Welcome once again to Lehto's Law. Here's Steve Lehto.
I may have mentioned before that I'm an attorney in the state of Michigan. And to become an attorney in the state of Michigan, you have to take the bar exam after you graduate law school. And you also have to pass character and fitness. And if you do all those things right, you become an attorney. You're licensed to practice law. Well, with COVID, a lot of states had trouble administering the bar exams. Some states made allowances for people who had done everything necessary, except for the bar exam, to practice law. And some people are now saying maybe the bar exam itself should be done away with. At least that's what the people in Oregon are saying. Ben sent me notes, and Steve, did you see this yet? And it's an interesting point. Oregon may drop the bar exam requirements and add options for new lawyers. And if they do that, it'll be quite rare. Noel Crombie wrote this for the Oregonian, or Oregon Live. The state organization that regulates lawyers, the state bar, has recommended no longer requiring law school graduates pass the bar exam to practice, offering additional routes to join the profession otherwise. So this is something that they're thinking about. The approach would set Oregon apart. The state would become the first in the nation to have 3 options for becoming a lawyer. Most states, you got to do what I described. California has always had another way you can do it. It's a little more complicated. I'm not going to get into it now. And apparently, Oregon is thinking about adding another option beyond that. So people could still take the exam, but could also rely on coursework and practical experience, according to recommendations by a task force put together by the Board of Bar Examiners in that state. And many people like to point this out. For instance, Clarence Darrow, perhaps the most famed lawyer in American history, attended law school briefly, and I think just thought to himself, why am I here? Because at that time, it wasn't required that you graduate law school. And he simply went and, in essence, apprenticed. And that's how many people became lawyers back in the good old days. So this is not without precedent historically. People in favor of this say the changes will lead to better prepared attorneys, as well as expand the pool of eligible lawyers to those who may not have the time or resources to prepare for the bar. Now, the bar exam did take preparation and a lot of time. I'll tell you that right now. Brian Golini, who's the dean of Willamette University College of Law in Salem and a member of the task force, said, "We are walking on the moon here. The proposal represents a significant departure from the long-standing practice of relying on the test to determine who gets to practice law. Oregon has used the bar exam since 1910. The current version is a 2-day process that includes essays and a multiple choice exam. And that's what Michigan had when I took it, and I think they still have it now. Candidates often enroll in expensive test prep programs and spend the weeks between graduation and the bar exam in July getting ready, or the bar exam in February, depending which one you want to take. They offer it twice in most states. And I can tell you, I took a bar prep course also. I literally set aside the months preceding the exam itself. Every morning, I would attend prep classes, and every evening, I would just sit there and study. I mean, I crammed for that test. I didn't want to take it twice. I know people who had to. Not a pleasant experience. Get it over with. In 2019, 1 out of 4 people taking the July bar exam failed, according to the Oregon State Bar. Some years, as many as 42% of the takers fail. And now here's the thing. The fact that people fail it is not an indication that the test is bad. It's just an indication that some people didn't quite do it properly. And so you can retake the exam. But, if you know there's an exam at the end of this long journey of academia and you don't pass the exam, you may have set off on the wrong path. But you may want to just study harder. And so the court is expected to consider the proposals at a public meeting on July 7th. The Oregon State Bar and the court are accepting public comment online. So if you want to comment on this and you're a member of the public, knock yourself out. The proposal comes a year after the Oregon Supreme Court took the unusual step of lifting the requirement that law school graduates pass the bar exam. The one-time change was made in response to the request by the state's 3 law schools in response to COVID-19 and issues that arose there. The court granted what is known as diploma privileges, allowing anyone who graduated from the schools and planned to take the bar in July to skip the test and simply be declared competent to practice law. And you should know that Wisconsin does that as well. In fact, I got a friend who went to law school in Wisconsin. Bar requirements vary among the states, where Wisconsin allows graduates of the state's 2 law schools to enter the legal profession without an exam if they qualified with the proper GPA upon graduation and also have to pass character and fitness. Now, here's what we're talking about. The group suggested transforming the second and third years of law school into a clinical-based model with a capstone project to be submitted to the Board of Bar Examiners for approval. Another option would create a post-graduation model for applicants to work under a licensed attorney for 1,000 to 1,500 hours and submit a portfolio of work samples to the board. There's some issues there, one of which is, as you might guess, it's about 2,000 work hours in a year if you're working 40 hours a week. And so 1,000 hours mean literally working for half a year, apprenticing, or 1,500 hours, which is even more than that. And the question then becomes, are you being paid for that, or is that like an internship? And then the second thing, of course, is when you hand in work, how do you know the person did the work? I mean, call me a skeptic, but I can tell you that when you're practicing law in real life, there's a lot of cutting and pasting going on because you're not reinventing the wheel each time. And so if I were to turn in a complaint and say, here's a lawsuit I drafted, there's a sneaky suspicion I'd have that you could compare that lawsuit to one filed by somebody else in my firm 5 years ago, and there'd be similarities to it. And in the legal profession, there's nothing wrong with that because some of these things are just honed over time. But to turn it in like it's a homework assignment, I got a problem with that. So meanwhile, Joanna Perini Abbott, who's the chair of the Oregon Board of Bar Examiners, said the proposed options would protect consumers at least as much as the bar exam. The board would still have final say over whether candidates have shown they meet the minimum level of competence, and candidates also still must go through the character and moral fitness review. This is not a free pass under either pathway. It's not take these courses and you get admitted to the bar. There is still a strong consumer protection avenue where the Board of Bar Examiners retains that control. So, I don't know. Remember, the idea of apprenticing, she says, keep in mind that many people who graduate law school have got a job lined up. And instead of studying for the bar and taking time off to do that, they could just go straight into work and start being trained by the people at their new job. But that's assuming that law firms want to take on that responsibility of teaching these people they've hired to work for them. And we've all had that before where you're working for somebody who says, I thought you knew what you were doing. I didn't hire you to teach you how to do your job. I mean, some training might be necessary, but you expect someone to come in and be able to hit the ground running, as they say. So one of the criticisms of the bar exam, according to somebody else, was that memorizing information and being tested on it under the stress of a timed exam is not a good test of being a lawyer. Some people think that. But you have to understand, the bar exam is not literally just give me the 5 elements of this crime. Give me the 3 elements of this crime. That's not what it is. Most bar exam essays are like fact patterns. Think of a word problem from math class, right? And it'll describe a situation. This person goes into a business to buy a thing. They buy this thing. They're told this about it. They walk out the door and they discover the thing is not what it was promised to be. Now this person wants to file a claim for fraud. Discuss. And so, you got to know what the elements of fraud are. But then you've got to remember how to apply those elements to that particular transaction and discuss it reasonably and have the whole explanation that makes sense. So it's not simply regurgitating facts on the exam questions, on the essay questions, on the exam. There's more knowledge and analysis that's required. And even the multi-state, which is the multiple choice questions, many of those questions are 2 to a page, multiple choice. And that's because there's a big fact pattern, and then there's a question, and then there's 4 possible answers. And it, again, is not just, give us the 3 elements of this or the 5 elements of this or how many cars do you have to sell a year to be a licensed car dealer. They're not that easy of a question. So I still think, in my personal opinion, the bar exam is the way to go. But other states have methods, like California, like I said. I guess what you really need to see happen is, let's suppose that they adopt these options. They say, fine, we're gonna do this. We're gonna have 3 different pathways to become attorneys. Well, it becomes a big experiment. And at that point, you have to look at it and say, okay, 10 years down the road, how successful are these 3 different groups of applicants who became attorneys? And you may have to look at it and see how many of them got into disciplinary problem, how many of them are still practicing law, and how successful they are. And some of those things would be very, very difficult to gauge. But it would be an interesting thing to observe. And so, I don't know. I guess the question then becomes, if you are in Oregon 5 years from now and you need an attorney and you sit down in an attorney's office, would it be a bad thing to ask, by the way, did you take the bar exam or how did you become an attorney? I think you have the right to ask that question. They're talking about consumer protection here, and consumers should know what they're getting for their money. So at the very least, I suppose you may have to ask that question and then ask yourself, oh, I've got somebody who apprenticed. I wonder if they learned what they needed to learn during their apprenticeship. So it's an interesting question. It's probably a big, interesting experiment if they do it. But as of right now, the discussion is Oregon may drop the bar exam requirement and add options for new lawyers, which would make them a rarity in the U.S. From the Oregonian, and Noel Crombie wrote it. Ben sent it. Thanks a lot. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If you're not supposed to eat at night, then why is there a light bulb in the refrigerator?